I'm attorney Jeremy Huss, owner of Huss Law. A question I often hear is whether the state can go forward on a trial if the victim does not appear. There are circumstances the state can proceed to trial if a victim does not appear or testify. There is a misperception the state must dismiss the case without victim testimony. Now, most of the time, the state may have to dismiss the case in this situation. However, every case is different, and it depends on what evidence the state collects during the investigation. If the state tries to present a victim statement without the victim testifying, the two typical objections raised are hearsay in violation of the Confrontation Clause of the 6th Amendment to the United States Constitution. The 6th Amendment guarantees a defendant shall have the right to confront all witnesses against him. However, the law does allow a trial judge to admit certain out-of-court statements over these objections under certain scenarios that may indicate the statement's trustworthiness. For example, statements considered a cry for help, or statements not made in anticipation of litigation, are typically admissible over a Confrontation Clause objection as long as the statements comply with the hearsay rules. The logic behind this is that a person who is crying for help and making excited, spontaneous statements immediately after an incident occurred is likely being honest. Although this is not always the case, obviously. Which is why this admission of evidence goes to the weight of the evidence. A trier of fact may decide how much weight to assign to any piece of evidence. The fine line of admissibility lies between a victim making statements seeking help or making more formal statements in response to fact-finding by law enforcement. Now, another way the state may proceed without the victim's testimony is if an independent witness observed the incident. Observations people make are not hearsay, nor barred by the Confrontation Clause. A neighbor or friend or family member may witness a crime between a couple or between people. The witness will be allowed to testify to all observations, including most statements made by anybody there. There would generally be no hearsay nor Confrontation Clause issues here. Any person charged with a victim offense needs to be careful to have absolutely no contact with an alleged victim in any way. This includes third-party contact. A court order will impose this, but it is very important to have no contact with the victim for other reasons as well. Very importantly, a rule of evidence will specifically allow an out-of-court statement by a victim if the defendant intentionally and wrongfully caused the victim not to appear. This is called the forfeiture by wrongdoing exception. Now, the state must prove this happened, but may do so through documents or witness testimony in an evidentiary hearing prior to trial. If the court finds the defendant caused the victim to not appear and had intent to silence the victim testimony, then the judge may admit the victim's entire statement, consistent with the rules of evidence, as if the victim appeared at trial. Examples where this may occur are situations as simple as a defendant telling a victim not to appear at trial, or threatening a victim not to appear at trial. Now, there are other ramifications for engaging in this type of behavior as well. For example, a person could be charged with tampering with a witness or influencing a witness. Both of these are felonies in Arizona. As mentioned, a person will be ordered to have no contact with a victim after a case is charged. It is very important to abide by this court order and have no contact with a victim at any time until the court lifts that condition. Any person facing trial is in jeopardy. It is important to consult with an experienced trial attorney. I have been handling Arizona trial cases for 20 years. Call me today for a free consultation.